Hey, what's up, y'all? This is David with I'm So Offended. We're going to do this here is the third part of this series about the income withholding order. Um, and so let's get to it. The video is for informational and educational purposes only. I'm not an attorney, and this is not legal advice. And we're not liable for any harm or misuse of the information in these videos. And let's go ahead and get to it. Um, all right, so starting off first, I think we kind of touched on it a little bit from the last video and the first video also, where I showed you what the actual income withholding order looks like. And if you've gotten it, they pretty much all look the same, right? I mean, there's no judge's signature, there's no seal from the court, and there's just nothing but threats, and it's a contract offer. Okay, so what? First and foremost, this is what a valid order is here. I think we touched on this a little bit. 28 U.S. Code 1691. All writs processes issued from a court. And maybe I should make this so it fits here. I didn't realize that I didn't have it at the right size. My bad. There you go. Maybe a little more just in case something else doesn't fit right. Yeah, I think you guys could still see that, I hope. It was just fitting in the ad. Sorry about that. So, yeah, all writs and processes issuing from a court of the United States shall be under the seal of the court and signed by a clerk thereof. And in that first video, I showed you what a seal looks like, what a clerk's signature looks like, what a stamp, and all of that. So that way there's no mistake. We know what a valid court order is. All right. So the withholding order itself, there's rules that they need to follow, right? And all things are governed by rules. The Code of Federal Regulations is the rules they need to abide by. So, of course, according to the withholding order, whatever gives it power, it needs to have these important things. So, in 45 CFR 32.6, it says it must have SF 329A form, an SF 329B form, an SF 329C form, and an SF 329D form. Okay? To the employer within 30 days after the debtor fails to make a timely request for a hearing, within 15 days after mailing the notice. It's all there. You can write it down if you can read it. But the thing is, all those are required. Okay? So, here's what they are. The SF329 forms here. All right. Administrative wage garnishment. So you can see there. Says the 329A, the 329B, the 329C, and the 329D, which is the creditor agency. Says the individual who is a delinquent debt to the federal government is referred to as the employee or the debtor, right? And it says failure to include all parts of the form other than B will not invalidate the wage garnishment order. So all parts says the instructions there, okay? Failure to include all parts of the form will not invalidate, okay? All right. Now, however, you can demand all parts, okay? They're not, the letter to the employer, and what it is, the 329A, it says the creditor agency is not required to insert any information on the letter to employer. An important notice to the employer, the creditor agency must include this letter as part of the administrative wage garnishment form to the employers when issuing the wage garnishment order. Gives the instructions, how it's completed, the amount, right? Now, the employer certification D, the SF329D, the creditor agency must complete the top part of the employer certification where indicated and include the employer certification as part of the administrative wage garnishment from mailed employers. Employers are required to complete the form and return it to the creditor agency within 20 days of receipt. So this is what it's saying it is. Employees identified and owing a delinquent non-tax debt. Right? And this is, you can see that it actually also adds the part in which I referenced in the last video, where in number 6, an individual may sue an employer who discharges from employment, refuses to employ or take disciplinary action against an individual subject to a wage garnishment order by reason of the fact that the individual's wages have been subject to garnishment. A court of competent jurisdiction shall award attorney's fees to prevailing employee. In other words, so the garnishment, them being told to do it, like they can't have any beef with you over the garnishment, right? But it works both ways, okay? And now you notice in the no retaliation, it cites a law there, right? Under 31 USC 370D. However, in the failure to comply, number 5, it says, fails to comply shall be liable for any amounts that the employer fails to withhold under the wage garnishment order, plus attorney's fees and costs incurred by the creditor agency enforce the wage garnishment order. In addition, the employer who fails to comply with the wage garnishment order may be liable for punitive damages determined by a court of competent jurisdiction with absolutely no case law reference there. Okay? This is a threat. Number 5 is a threat. And that's how it's supposed to be filled out. Basically, it's presentation, the amounts, wage garnishment worksheet, how they calculate everything, obviously there from the paycheck, the amount compilation. Interesting that it says on number 5 there, 25% of disposable pay. We'll take another look at that later. Watch. And here's the Part D, to be completed by the debt creditor agency, and the certification to be completed by employer. All withholding orders with priority. And there's your standard form. All right, so you can file an objection, right? Obviously, under all those rules, especially if they're not providing all parts of the document. If it doesn't have a seal. And from here, now we're looking at, I just want to show you what it is I'm looking at here. So this is 15 USC code 1673. So the restriction on the garnishment, we're looking at number B, right? It needs to follow everything. So the rules here are if you're afforded substantial due process, subject to a judicial review. Okay? So this is just basically outlined that all the rules need to be followed. And then it references again here in 31 U.S. Code 3720 Part D, right? So that is Part D, garnishment. We're going to go down to E. Same thing as far as employer may not discharge from employment, refuse to employ or take disciplinary action against an individual subject to a wage withholding in accordance with this section by reason of the fact an individual's wages have been subject to garnishment under this section, and such individual may sue in state or federal court of competent jurisdiction to take action. Right? And in 15 U.S. Code 1674, again, it says, that you're protected as far as they can't have any beef with the garnishment and your objection to it. May discharge any employee by reason of the fact that his earnings have been subjected to garnishment for an indebtedness. And we'll look further here in the restriction on garnishment again. And this is about the amounts. 25 percentum of the disposable earnings. Okay, remember we looked at that before, right? So I know that there's some guys being taken for 50, for 60%, and all that. And this isn't so much as you're complying. This is so much as saying, like, you need to follow every single part of these rules before you can do anything. Okay? Anything. So this is just basically building your entire foundation for your objection to the employer along with the cease and desist, right? And I showed you a copy of the cease and desist in the last video there. And so where that comes from is from the state of Wyoming here in Nell versus Nell. Right? So this is Bruce Henry Nell Jr. appellant versus Tanya Louise Nell appellant defendant. And this specifically has to do with child support, actually. And so the appeal presents a single issue. Did the garnishment ordered by the district court exceed the statutory limits on credited garnishments? So the facts, it goes through and basically explains the whole case, right? But what we care about is the discussion and their ruling, right? The Federal Consumer Credit Protection Act, right? And this is in a child support case. So therefore, it has to comply with the Consumer Credit Protection Act. Okay, limits the amount of individual earnings that may be garnished. Okay, it provides in relevant part maximum allowable garnishment, except as provided in subsection B and in section 1675 of this title, the maximum part of the aggregate disposable earnings of an individual for any work week which is subject to the garnishment may not exceed 25% of his disposable earnings for the week. Okay. Now, let's get down to the ruling. All right? Right here. So, because we conclude that a support order must be treated as a garnishment, okay, this Supreme Court law ruling is appellate review, actually, okay, because there's Supreme Court law which can be overturned in appellate. So, appellate is when a matter had already been discussed and it was looked over again in appeals. So appellate is the case law that you really, really like, that you really want to use. All right, so credit or judgment garnishes may not be imposed only to the extent support garnishments may be imposed only to the extent support garnishments do not exceed the general 25% limit. Mr. Nell's monthly disposable earnings totaled $3,350, and his monthly child support obligation is $1,393. His support garnishment is therefore approximately 42% of his disposable earnings, which precludes any additional creditor garnishments. The district court thus erred in enforcing the additional garnishment for the property settlement debt to Ms. Nell reversed. All right. Now, we also want to state that it's when you sign on to work for a company and you fill out the the tax information, and they give you a certain amount of documents, which is basically an employer-employee agreement. So you made a contract with them, right? So here in Trual versus Reich, I may have gotten it wrong, but pronounced it, but that's 239 U.S. 33. It says here that the fact that an employment is at the will of the employer, an employee, does not make it one at the will of others, and unjustified interference of third parties is actionable, although the employment may be at will. So what we are saying here is that the employer has the freedom to exercise his judgment. In other words, doesn't have to comply, right? Because it's a contract offer, right? So therefore, without illegal interference or compulsion or by the weight of authority, the unjust interference of third persons is actionable, although the employment is at will. In other words, actionable, which means there may or may not be an action. It is actionable, which is possible, but it's not required. All right, and this is one of my favorites here. Because when you make a contract with your employer, right, under Article 1, Section 10, the contract clause is the individual may stand, this is one of my favorites, actually, Hale versus Henkel, right, 201 U.S. 43, was decided in Supreme Court. There is a clear distinction between an individual and a corporation, and the latter, being a creature of the state, has not the constitutional right to refuse to submit its books and papers for examination of the suit of the case. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business, or to open his doors to an investigation, so far as it may tend to incriminate him, right? Now that's when you think about the Fifth Amendment, right? The right to remain silent. He owes no such duty to the state, since he received nothing therefrom beyond the protection of his life and property. His rights are such as existed by the law of the land along as antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are a refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. Hale versus Henkel is binding on all courts of the United States of America until another Supreme Court says it isn't so. No other Supreme Court case has ever overturned Hale versus Henkel. None of the various issues of Hale versus Henkel has ever been overruled. It's been cited over 1,600 times. In nearly every instance when a case is cited, it has an impact on precedent authority of the cited case. And so finally, it interferes with the contract clause. If you made a contract with your employment, they are interfering. And let's not forget 42 U.S. Code 653A. All right. And these are the penalties. These are the actual penalties, because you can see that they're lying here. They're lying in what they're saying in this form, where an employer who fails to comply with the wage garnishment shall be liable for any amounts that the employer fails to withhold under the wage garnishment order, plus attorney's fees and costs incurred by the creditor agency to enforce a wage garnishment order. Well, you know what? Actually, this is all you can do. There it is. Civil money penalties on non-compliant employers. The state shall have the option to set a state civil money penalty which shall not exceed $25 per failure to meet the requirements of newly hired employee, or $500 if under state law the failure is the result of a conspiracy between employer and employee to not supply the required report, supply a false incomplete report. So, in your objection to the employer, you can tell them, I'll pay the fines. I'll pay the fees. But something I won't do is consent to this, and I will file a lawsuit against you. The Attorney General and the Child Support Agency does not owe you an attorney to defend you in a lawsuit that I will file against you for complying with this income withholding order. And lastly, I want to state that there's this group that I'm in where this guy posted, and he said that he just Zells his baby mama $25 a month, and the child support agency doesn't mess with him because he's doing it voluntarily, he's doing it willfully, and he's showing proof. Okay, they don't have any proof of his wages or earnings or anything that he does. They can't just assess an amount, right? I mean, they try and they do, but the thing is, without proving that he has the ability to pay, he is remaining in honor and sending her $25. So, and we already went over it in where some states it's 25 or you can do 50, and you could just send that. And this guy doesn't get his license revoked, doesn't get his passport revoked or nothing. So I'm going to try and get in contact with that guy. Hopefully he could share his story. But yeah, this is something that I've seen. Okay, so when I state whether it's something that I do or something that I've seen, I will explain and tell you the difference. All right. And so as far as the guys that I've talked to from the last video, I told you that was something that I seen, and that guy showed me proof that he stopped his wage garnishment order with the cease and desist letter. Right. There was another guy I spoke to that also did the same thing. And then the way that I had it stopped, or rather just didn't happen, is I just talked to the employer and I told her just to send it back. Nothing happened to me, nothing happened to these guys, and this other guy, that his story is he's just paying $25 a month. All right, so whatever it is you guys choose to do, if you have to try all of them, if you first have to talk to your employer, or then you have to do the cease and desist, and then you can file the lawsuit, whatever it may be, do whatever it is you have to do. All right, so review all the videos and see which one applies to you and that you can use, or just use them all. Let me know how it works out for any of you guys if you're doing it, or what's going on with your situation, just so we can try and spread awareness. And hit the like button, hit the shares with anyone that has a income withholding order. And I'll update you guys as when I've been talking to other guys, and and they've been telling me about their contempt proceedings and stuff like that. So I'm waiting to hear back from some guys, but to my knowledge, I know of 2 guys that have beaten it now. And I have another guy that just went through a hearing in which they just kind of rescheduled it. And so, we're just applying the pressure, and just trying to stay afloat, trying to live our lives, and try to settle everything honorably in person and stay out of court. All right, guys. Thanks for the likes, comments, and shares. And check the links for the donation or hit me up on the email. That's all for tonight.